litigation. I also have a Masters of Law, Masters of Tax Law in Corporate Transactions, meaning mostly mergers and acquisitions, and I have a Masters of Public Health Policy, where really you learn the lay of the land. And I think with a combination, it's almost a stacking of these degrees, and my career path has kind of stacked itself one on top of the other. And you become a pretty interesting, you can read strategies as people talk about them, as people go through them and they plan for them. And I think that's like a big benefit of having this sort of a background. And not only that, but having an accounting background is hugely important to me because anything that we touch always has dollars and cents at the end of it. And if it doesn't make financial sense, you really have to look at the legal sense of it. So I've had a background in some large size organizations, some small and mid size as well. I've been with Broward Health before. I've worked for Jupiter Medical Center. I've worked for a few other hospital systems along the way, including Yale New Haven Health. I've negotiated a lot of contracts. I've reviewed a ton of contracts, and I've litigated probably more cases than most attorneys have in their lifetimes. I am licensed in Florida and Washington, D.C. I was formerly a CPA. I'm no longer, but formerly, I was formerly a certified healthcare compliance officer and a quality ISO 9000 auditor. So today, as we talk about, so I signed a non-compete. I kind of want to put three different scenarios out there for you before we get started, because it's nice to have the context or the lenses that I'm looking through, and just to be able to help explain what the stories are about. So first, let's talk a little bit about, well, remember, this is a presentation. It's for informational purposes only. It's not legal advice. And this seminar is an open forum, live, and it is being recorded. So if you're going to ask questions, do know that they will be recorded. Now, otherwise, you can always ask them at the end when we will stop the recording, and we'll take questions afterwards in case if there's any questions that you don't want recorded as a part of this webinar. So let's start off with, let's say, as you may have heard, there's a lot of mergers and acquisitions going on nowadays. And with the mergers and acquisitions, where does that put non-competes? If you sign up with company A and company A merges with company B, you never bargained for company B. You only were looking to be employee of company A. Where does that put you? And we're going to help answer some of those questions today. Also, there's what I call the MSO shackles, like the management services organizations. A lot of practice groups are either have on the side, or they contract with management services organizations. And these management services organizations have their own set of rules that they want the physicians to follow. So a lot of times you'll see contracts like a physician employment contract that will refer to a management services agreement and ask for the physician to comply with the management services agreement, even though both have never been put together in front of the physician to take a look at. And that's a hard pill to swallow, because it's really, really a big pill to swallow. You're not only working for one employer, but you end up working for two employers, and they may have different sets of conditions that they want you to follow. So the third scenario I want to talk about is a hospital situation. In a hospital situation, you typically have specialists, right? And those specialists work at the behest of the hospital. Now, they can have radiuses that could be large or small. Most hospitals tend to carry a 10-mile radius to them. I've seen them as low as 5 miles, and I've seen them bigger in some practices as much as 30. Now, there are other extreme scenarios that I can tell you is I've negotiated non-compete agreements to be geographically as small as 1 mile radius. And then I've also seen non-compete agreements that are for the whole entire country, that you can't go work for another competitor in the whole entire country. And those are problematic scenarios. All of these scenarios are problematic, and they have their nuances. So as we go through the slides today, hopefully you'll get a chance to kind of think about the PE scenario, like what happens when two companies merge. What happens when you have an outside organization that is contracted with your employer, and now you got to abide by both the organizations at the same time? And then last but not least, there's also the hospital scenario and the practitioner scenario. So, as most reasons go, why do people or why do companies have non-competes? Number one, it's because developing and having a healthcare business is really expensive. The infrastructure is expensive. The patient acquisition is expensive. It's just they have buildings, they have technology, they have marketing channels that they have to protect. So because it's so expensive to build these practices, they will have non-competes. Now, what happens in a non-compete scenario? Well, employees or physicians lose their freedom. They almost become commoditized. They get restricted. Their feathers get cut. Their wings get clipped, and they have a much harder time figuring out what the next step is, and they really have to think through it methodically before they proceed. Now, as far as patients go, this is all intended to keep the infrastructure costs lower. So maybe it helps the patients by keeping their insurance costs lower, and hopefully it keeps patient choice still robust enough that they can find the right physician. But if they can't because of a non-compete, that causes problems, right? So for the patients, it's a mixed bag. It's not exactly positive, but it's not exactly negative. But for the healthcare businesses, it's definitely a positive move to have non-competes. For physicians, it's generally a difficult pill to swallow, but they swallow it, and we'll talk about how you go about doing that. So from the time that we started today to the time we end, it'll probably be about a 50-minute presentation. I'm going to try to go slow through certain parts of it just to make sure that I've elaborated enough, but I'd really like it if you guys would ask questions along the way, because it helps me understand as to whether I'm teaching appropriately or whether I'm covering the materials properly or not. So I would really like that. So first thing that we're going to do today is we're going to talk about non-competes and restrictive covenants. Then we're going to talk about the Florida case law. And then really parts 3 and 4 is where it gets interesting. What happens when there's a sale of a practice? What are the impacts on a restrictive covenant? And number 4, we're going to talk about checklists for negotiating, performing, and litigating employment agreements. And that's where it's going to all build up to that level. And that's the part that I think is going to be most useful to you. In the end, you'll have a little bit of time for Q&A, but do ask these questions along the way if it's appropriate to do so. So before we get started, I also want you guys may or may not have thought through this, but there's generally 4 different tracks that physicians follow. And I call them almost stepping stones, right? So when you think about non-competes, you really have to think of them in the context of what does the future of your employment look like? In the future, do you expect to be in a small or individual practice? And then your non-competes will be tailored a little bit differently? Or do you expect to go from a large size system to another large size system? And there, in what capacity are you going to serve? Are you going to be a clinical provider, or are you going to be in management? And for that, the non-competes are also very different. If you're actually a provider, you can see that if you're a provider, most patients stay within a 10-mile radius of where they live. But if you're in management, you may be impacting a whole state or multiple states. So your non-compete will be very different. Again, you have hospitals that are not-for-profits and that are teaching hospitals, and they have specialists inside their organizations. So how do non-competes work with hospitals? Like, what if you decide to go from, pulmonology to like intensivist position, right? Will that impact you? Well, we're going to talk a little bit about that today. The next thing that I also want to touch on is there's also the move towards private equity groups and health plans and working for these big corporations that don't really provide face-to-face patient care, but they do have a backroom function that they serve, and they're really, really large size organizations. And their non-competes will be very different. So let's get started with the basics of what is a non-compete. You may have heard about non-competes and restrictive covenants. Just remember that a restrictive covenant is a broader term for non-compete clauses. So restrictive covenants can mean don't go work for your competitor. It can mean don't recruit other employees. If you leave your employer, don't recruit other employees and take them with you. It could mean that also don't take any of the vendors from your prior employer to your new place of employment. Like, for example, you may have a really unique sort of a service provider, and you think that they're going to do well for you at the next location. Well, you may have a restrictive covenant that keeps you from recruiting that vendor to your next practice. Obviously, there are restrictions as to patients a lot of times. And then there's also restrictions as to business information. So you may end up signing a NDA. Now, the word restrictive covenants has a lot of different meanings in law, but in the context that we're going to talk about today, it's going to be in the context of healthcare. We're going to talk about competitors, recruiting other employees, vendors, patients, and keeping business information confidential. Now, typically, non-compete agreements are between an employer and an employee. And as I had mentioned earlier, it may even involve a MSO. But typically, it's between an employer and an employee. It is independent, but stands alone and and is usually in conjunction with an employment contract. So sometimes the employment contracts will have the non-compete embedded right in it. Other times, a non-compete agreement will be a standalone as a supplement to the employment agreement. So it can take two different forms. So just keep that in mind. Now, when it comes to employment agreements, there are several different types of employment agreements. You may be given something like a independent contractor agreement or a service agreement. And sometimes they even come in the form of shareholder and operating agreements. So you may become a part owner in a company, but they're going to ask you to sign a restrictive covenant. So you can find your restrictive covenants in pretty much any of these four types of agreements that I mentioned over here. And the restrictions can apply to the medical specialty area that you're in, the geography where you're located, the specific patient base, and also you may end up agreeing to not poach any of their employees, not take any business records, and not take any of their tools and techniques or trade secrets along with you. So remember, Florida places the burden of proof largely on the former employee that violation of such an agreement does not occur and does not cause irreparable harm to the party seeking the enforcement, meaning the prior employer. So Florida is a very employer-sided state. It's not employee-sided. And with that, Florida also has a restrictive covenant, which is a statute, which is 542.335. If you're joining us from a different state, almost all states have similar sort of statutes. It may read a little bit differently, but it's going to have similar elements to it. So what the Florida statute requires is that the employer has a legitimate business interest, and that always depends on the special facts and circumstances of the scenario. So meaning that a employer who's trying to restrict an employee should have something that's unique, that's of value, that they can put their finger on it, and it'll depend on special facts and circumstances of that situation. So like, for example, if you are working for an employer that is an oncology practice, and the oncology practice, let's say, specializes in maybe liver disease or something, well, that's a very specific area. Is there a legitimate business interest or a legitimate business concern? Yeah, it starts to look more and more like it because you're in a very narrow area related to a particular type of medicine, and it's in a particular geography. So that's what the courts will look for. Is there a legitimate business interest that's being protected by the restrictive covenant? And then what they will see is, does the employee gain an unfair advantage by being employed by the employer? If they did, then you know what? It starts to look more and more like that the restrictive covenant is going to be valid. The restrictive covenant must also be reasonable as to time, area, and the line of business that's in. So just know that there is no black and white rule when it comes to time or the geography or the radius to the geography and the line of business. However, the courts have interpreted that 2 years limitation is reasonable. 4 years or more starts to look more and more unreasonable, although they have not said what is unreasonable. So um, that sort of stuff, rulings are out there. Keep those in mind. And last but not least, all restrictive covenants must be in writing. If they are not in writing, they are not enforceable in Florida. The statute expressly prohibits the court from considering any individualized economic or other hardship that may be caused to a person against whom enforcement is sought. So a lot of times people think that because they have a family, they may have little ones, maybe they can plead the case of it's an undue hardship on my family, my little ones, it's economically debilitating. Well, the statute expressly states that the courts cannot consider that. And that's something to take for real when you are looking at a employment agreement, because whatever you negotiate today is what you're going to have to live with later on, and you cannot bring up the other facts and circumstances as to how much of a hardship it causes you. So in this case, what I would suggest to you is negotiate up front. If you do end up running across a scenario where you have a employer pushing to enforce their restrictive covenant, you can argue hardship, but it's going to be hard to do that in front of a court. Now, another little known rule out there is this one, 542.336. What that basically says is that, Florida did not want to cut off the people's ability to compete entirely. So what they said was, if there's only one entity inside a county that is providing a specialized sort of a service, that they cannot have a non-compete agreement if there's only one entity that's providing that sort of a service. Okay, because what Florida reasoned is that there is not a legitimate business interest, that it actually hampers competition. Now, let's say that going back to that same liver oncology practice, let's say that exists in Lake Okeechobee or Okeechobee County, and there's no other. Let's assume that to be true. Now, a new one comes into Okeechobee County that's a competitor. Well, what the statute basically says is that non-compete, if they decide to implement a non-compete, they cannot implement it for 3 years till the second entity has been there for 3 years, and only then can they do it. So essentially, what they're saying is, let the new competitor move into the county, let them set up shop for 3 years, and then do restrictive covenants. So that happens in rural America or rural counties in Florida, but this is a very less discussed rule, but it's out there. Now let's talk a little bit about 21st century oncology versus Moody. Moody was the former Attorney General of Florida. It was Ashley Moody, and she stopped 21st century oncology from enforcing a preliminary injunction against a physician. And what they argued in that particular case was that there was no legitimate public purpose, that the non-competes actually become void or voidable, meaning that they can actually be negated by the court, and that the public purpose is to really reduce cost and improve patient access to physicians, and therefore a preliminary injunction should not be allowed. Now, for those of you who don't know what an injunction is the right for a party to seek the doing of something or stopping of something. So you can actually do a injunction to stop somebody from, let's say, competing in the same area. It would be called a injunction, and that sort of litigation is really difficult. It's tough. There's a lot of legal work that goes into it, and it takes a little bit of time to do. Next case law that I wanted to bring to your attention was Humana Medical Plans versus Ira Jacobson. Ira Jacobson was a physician in Miami, and he actually left. Well, actually, it might have been Broward, come to think of it. And he actually left his practice, and in his practice there was a HMO contract which said that if anybody leaves this practice, that they cannot go after the patients related to that HMO. However, in this particular case, Ira Jacobson moved away, and the patients followed him on their own. Ira Jacobson did not solicit any sort of business from the patients, but the patients were looking for him. So when a patient goes and looks for their own physician, well, what they've interpreted that to be is a patient's right to choose their own physician, right? It's just like choosing your own lawyer, it's like choosing your own priest. It's such a personal issue that the courts will not enforce that. If Ira Jacobson did not solicit prior patients, the patients have a right to go and find their own physician that they may end up following. So, and the case law actually goes on to say, when an ailing person selects a physician to treat him, he does so with the full expectation that such a physician will do his best to restore him to health, and the contract into which they enter is deserving of more attention from the law than a businessman's expectation of profits from a purely commercial transaction. So they clearly said, do away with non-competes if the patient is looking to follow a particular physician to another place. By the way, do keep in mind, in this particular situation, what the patient would have had to do is they would have had to change insurance companies, because the restriction was as to the was created through a insurance company contract. They would have to actually change their insurance company to be able to get access to Jacobson, because the insurance company could have stopped Jacobson. So, like, let's say Humana had a contract with Jacobson. When Jacobson left and the patient followed him, Humana could have actually terminated their contract with Jacobson, and that would have been perfectly legitimate to do so. Now let's open up another interesting scenario. Here's open magnetic imaging versus Mirta Neves. So Mirta Neves was already working for this employer, and as she's working there for a few years, the employer comes to her and says, "Hey, I want you to sign a restrictive covenant, a employment agreement that has a restrictive covenant in it." Nieves was not a physician, but she was a physician relations representative. And in that particular scenario, the court said that that was perfectly good to do so, even though it was after she became employed. Her argument was, hey, I never knew about this contract. These guys sprung it on me after I'd been working here for a while. And what the court reasoned was, if Mirta had wanted continued employment, she needed to sign it. If she didn't, she had the right to walk away. So it was up to her whether she chose that contract or not. Also in this contract, she was restricted to a 10-mile radius, and it was for a period of 2 years. Now, remember, in Florida, employment is an it's an at-will state, which basically means that an employer can hire or fire a employee for any reason or no reason at all. And signing a non-compete in exchange for continued employment is deemed adequate consideration to enforce that non-compete clause.
Ben,
So
I have a question for you, Ben. Real
Sure.
quick. I want to go back to that doctor one, where the doctor with the patients go back 1 or 2, I guess. And if I'm a physician and I leave a practice and I don't have a restriction of where I could practice, but the same situation with Humana, and the patients want to come to me, could I advertise that I've opened up a practice in that local newspaper, local whatever, local periodical, whatever it may be, to give people the ability to understand of where I am right now? Would that violate anything?
In most contracts, it would not. Most contracts don't have that restriction or limitation. However, I'm starting to see more and more of these these limitations, even as to social media. It has not quite gotten there yet. I do see it on rare occasions, but for the most part, um, physician non-competes do not cover general media provisions like the one that you just mentioned. What if you advertise in a newspaper? Even social media sort of stuff, right? That's a general sort of a statement.
Right. Okay.
Where is a
Thank you.
person? The person's not directly soliciting. You're welcome.
What happens if you put like a big billboard up with your picture on it right next to the hospital?
I love it. I think that's awesome. Again, I think the same rule would apply. Is it specifically stated in their non-compete agreement that they cannot do broad-based advertisements within an X radius of the hospital?
Right.
If that's in place, then they won't be able to. But for the most part, it's not. It's not in most contracts.
Okay, great. Thanks.
So where's the country headed now? And I think we've heard a lot of talks about how the Federal Trade Commission has put forth a paper that basically says all non-competes should be done away with, and they've asked for input from different industries. In the healthcare industry is probably the one industry that has the highest likelihood of getting that approved, but I still put a slim chance on it, only because there's a lot of specialty interest groups that have their hands in the pot. Just the way the political process works, there may be something that comes out, but I don't think it's going to highly favor individuals that get paid a fairly large amount. So like they may in fact just have some sort of a threshold of cutoff. If a employee makes more than 100,000 or 200,000, that it's perfectly fine for them to have a restrictive covenant. Then they may actually, the eventual rule may end up saying something like that. I wouldn't be surprised about that. I wouldn't actually in fact expect it. So as people talk about what's going on lately in the state of affairs as to are we doing away with non-competes? Well, they're trying, but it's not going to happen, guys. I don't know. I hope I'm wrong. But I don't think it's going to happen. So now let's talk about what happens to a non-compete provision if a practice is sold, right? So in this particular scenario, what I was thinking about was, let's say that there is a practice. The practice has a physician or multiple physicians that work in it. Once that practice is sold to a different company, what name is it going to carry? Is it still going to carry the same old name that it had before? Or is it going to carry the new name of the new business? Or is it going to be a merger, which is a technical term in the legal world? Or is it going to be an asset purchase? So if it's an asset purchase, the contracts don't always transfer over. They could, but they don't always transfer over. If it's a merger, the contracts do transfer over by operation of law. So just know that in a merger, yeah, you're looking at basically restrictive covenants going on to playing a role for you at the next employment situation. In the combined company, your non-compete provisions will still apply. However, if it is a sale of assets transaction, then it may or may not apply. It depends on whether the physician contracts were sold as a part of that transaction or not. So that's when you actually have to look into the underlying documents to know whether a particular physician agreements traveled onto the new company name or not. And also keep in mind, if it has to have a assignment clause, if the contract is changing hands from one company to another company, it has to have what's called an assignment clause. If it doesn't have an assignment clause, then it's not going to be deemed to be a legitimate transfer. All right, so here is a slide. I have a camera sign down below. If this is one of those slides that I would keep in your memory or in your camera and take a picture of it. So when you are negotiating your non-competes, what should you look for? What you want to look for is geographical limits, number one. And you want to make sure that the geographical limits are limited as to the place where you work the most in the last 12 months. If it's older than like past 12 months, should it really even apply? No, right? I mean, like for example, you start to go work in the middle of Fort Lauderdale, and then you get transferred up to like let's say Lighthouse Point, and then from Lighthouse Point you end up finding your next employment out in Weston. Which place should apply? Well, it should really be your last place of employment, not the first place of employment. And so what I do is I typically negotiate for the place where the physician worked the most in the last trailing 12 months from the time of departure. So that's your geographical limit sort of a concern that you want to talk about. The other thing is you're going to want to come up with a radius that makes sense for you. If you are a highly specialized specialist, you may have a bigger radius, but let's say if you're a general practitioner, your radius is more likely to be a lot smaller. You're more likely to end up with a 5 or 10 mile radius. But if you're a highly specialized, some sort of like, let's say, I don't know, a neurosurgeon that specializes in a particular type of brain cancer, I could see that radius being 20 miles or 50 miles because it's a highly specialized thing, and you don't want a competitor. The employer may not want a competitor, want you going and working for a competitor that's within 50 miles. Again, it's based on the expectation of how far you expect the patients to drive to go and see that specialty. That's how I look at analyze geographical limits as to should it have a large radius or a small radius. The other thing to keep in mind is negotiate a fair time restriction. 1 year is actually good. 2 years is kind of the limit, and 3 years gets to be too long. So look for really 2 years or less is what you're looking for. I try to negotiate a 1 year limit on all anytime I represent a physician. If I represent an employer, it's almost always 2 years. So now review the assignment clauses for the contract when you're reviewing your contract. The other thing to actually look at is the scope of services you would be providing in that contract. So, for example, you may qualify to provide 3 different types of services. Let's say you have 3 different board or 2 different board certifications, and that they're sufficiently different from each other. What you may want to do is you might want to just restrict your employment with this particular employer that doesn't overlap with the other employer. So I don't know, let's say internal medicine and surgery, right? So let's say you're dual board certified internal medicine and surgery. If you go into a setting where you can act as a surgeon, then just use your surgery specialization. Because if you come out of it, you may want to just go and be a general practitioner, and your internal medicine is what's going to play a role there. So you can almost separate it and divide it into the type of specialty by the scope of the services that you will be providing. Another very rarely seen scenario, but I always like my physicians to think through this, is consider a buyout provision. Ultimately, what the employers are looking to do is they're looking to inflict enough pain so the physician just doesn't get up and leave their practice willy-nilly. And similarly, physicians don't exactly want their wings clipped in its entirety. They want to be able to have some level of freedom. So you may want to consider putting in a provision for a buyout. So for example, if the physician is in violation of the non-compete, that they have the right to buy out their non-compete by paying, let's say, $75,000. If they pay $75,000, it's painful enough for the physician. Yeah, but at the same time, it doesn't clip their wings from doing the next thing that they want to pursue. So these are just some tips of the trade that we have. Now, while performing in the contract, if as a physician somebody is getting ready to leave, what I always tell them is, if you think you're going to be leaving and violating a non-compete agreement, just make sure that you walk out with something that is of value to you, because a lot of times we can use things to help us barter, right? So I always ask my physicians to look at the employer, take a look at, what is the employer deficient at, and make sure you get a level of documentation, which is what added to your dissatisfaction with that employer, and take it with you, because you need a certain level of proof in case if the employer was completely neglecting their duties and now you want to leave. You need something in hand to be able to reason out as to why you left. And that's why you would actually come up with something, actually gather enough proof that you had something like that occurring. Once you leave, that proof is really, really hard to find again. Now, what happens if you leave? The employer is responsible for relaying messages. Sorry, no, this is during your employment. The employer is responsible for relaying messages from patients to you. The employer oftentimes takes on the role of reordering prescriptions so that they coordinate it. They may have a prescription reordering group or department or a designated person that actually does it. And they'll oftentimes have, glitches in these systems. The coordination of patient services is another really important function that a lot of employers do very mediocre at. And keeping accurate records is another part of a employer's obligation. Are they keeping their records accurately and effectively, or are there records that are missing? Are there things that are not being captured that should be captured? And having a clean and suitable environment is a given, but believe it or not, some employers do not have a clean and suitable environment. And once the physician complains about it enough, it does become an issue. Now, once you leave, the other party, the employee can ask for their employer to give them the billing report with their NPI number. They can ask them for billing detail by location. They can ask for billing reports by physicians and patients and all ancillary services. These are normal sort of reports that the employer should be able to provide a physician. If they're not, there's some sort of an issue that's going on, and you got to get to the bottom of it as to why the system is not capable of doing that. So, like, for example, if your NPI number is being used to bill something, why can you not have a billing report that shows your NPI number on it, right? So these reports become handy. So this page 15 is an opportunity where you can actually take a look at what's missing in your employment relationship currently before you go on to the next one, so you can make sure that you document it properly. Now, the next one is beyond the contract. So what happens to your ethical and statutory requirements once you leave a place? Well, you or the former employer is required to give notice to the patients that you are no longer there. Simultaneously to that, you are required to update your records at the Department of Health as to where you can be found, because the Department of Health has to be able to find you. And remember, I think the limitation of that is like 30 days. So you got to do it relatively fast and soon enough. And that's oftentimes the way patients will find their physicians, as to where they've moved to. So the patient must also be given notice of where they can obtain patient records. So if you're actually getting up and leaving a practice and you're no longer going to be seeing that particular patient, and nobody else is going to be either, then the patient needs to be given a notice as to where their patient records can be obtained, especially if the business is closing up shop. Now, do keep in mind that we touched on this a little bit earlier. Building a social media is really a great way to let people know where you are and where you're headed to. Now, that's also the obvious place that the former employers will go to find out where you are, and if you're in violation of your non-compete. So it's a double-edged sword when you broadcast things through social media, or you can hold off till your non-compete is resolved. Now, you may want to build a advisory website too. That's another thing to consider. Like, for example, you may want to have one that says Dr. Joe or drben.com or drdavid.com. So when you build these sorts of websites, you can publish articles on it. You can put your favorite stuff on there, the things that concern you. And then it's also a nice place for your patients to go and read up as to what's top of mind to you, and also know where you went. And that would be the patient looking you up, not, not you recruiting that patient. Like Charles had also talked about earlier, you could do general advertisements since most contracts do not restrict that. But general advertisements is a way to also let your patients know where you are. You can advertise in the local papers, bus benches, association papers, and even on Google and Bing, you can change your addresses on there. So with that said, this is our last slide that we're going to be covering today. This is litigating non-competes. There are 7 ways to actually litigate non-competes. And you can litigate them over several factors. And these are all factors, and each, depending on how egregious it is, it could help you knock out parts of your non-compete, but probably not the whole thing. So first one is that the employer breached the contract. Ideally, you want to have a scenario where the employer missed paying you. They did not pay you appropriately, correctly, and even after the employer knew about it, they still did not pay you. Something like that. Or maybe having an unsafe environment, or maybe having not the right tools, and repeatedly not the right support. Those are the employer breaches. The other thing is, you could also argue that there is no legitimate business interest for the employer to enforce. We had touched on LBI way in the beginning. I think it was like slide 6 or 7, but 5 or 6 maybe. So yeah, so you can go back and look at that. The other thing to consider is confidential information. You can argue that the confidential information that the employer is saying is confidential is not really confidential. It's actually available in the public domain. And if you do that, what that'll mean is there was nothing specialized about that particular situation that the employer was pushing on. The agreement period, a lot of times, again, if the agreement period is 3 years or more, chances are it's going to become questionable. But what does this all mean in the end? What will the courts do? Well, the courts have what's called a blue pencil rule. They can go in and blue pencil and edit out those parts. So like, for example, if the non-compete agreement says 5 years on it, the courts have the leeway to go and blue pencil in, instead of 5 years, strike it out with a blue pencil and now put down 2 years or 1 year or whatever that the court believes to be reasonable. Same thing with geography. If it has a 50-mile radius, the courts may be agreeable to narrowing it down to, let's say, 10 miles or 15 miles. Again, the litigation as it relates to non-compete is really more about revising the non-compete, not necessarily about striking it, because striking it is really, really difficult to do unless if somebody really royally messes up. So with all that said, I think I've given you enough tools as to what to negotiate. I think I've given you enough tools as to what to look for when you're getting ready to depart, how to keep your patients informed, and also, if it comes down to it, how would you actually contest a non-compete provision? And that's what this slide is. Now, just keep in mind, I mean, the reason why Charles and I do this is really to play a role in our community, in the healthcare community, for the betterment of not only the physicians, but the lives that we all impact. And hopefully you've gotten something out of today. If you have any questions, you are welcome to ask them now. Charles, any other statements, questions?
No, I don't think so. I mean, I'm going to stop the recording now. So feel free to